क्या आप भी कानूनी जजमेंट्स को समझने में घंटों लगाते हैं? ये काम अब आसान हो सकता है। पेश है लेक्स जीपीटी, एक ऐसा एआई टूल जो आपको किसी भी कानूनी जजमेंट को सेकंड्स में डिकोड करके समझने में मदद करेगा। चाहे कोई भी कानून हो, कोई भी जजमेंट हो, लेक्स जीपीटी आपको देगा सटीक और तेज विश्लेषण। और खास बात, आपको मिलेगा फ्री स्टैंडर्डाइज्ड प्रॉम्प्ट जो आपके एनालिसिस को और भी बेहतर बनाएगा। अब समय बचाइए, काम कीजिए स्मार्ट और बढ़ाइए अपनी सफलता की संभावना। लेक्स जीपीटी किसी भी कानूनी जजमेंट को समझें तुरंत और आसानी से। अभी खरीदें और आजमाइए।
टैक्स लॉ से परेशान हो? टैक्स लॉ से परेशान हो? अब चिंता की कोई बात नहीं। लीगल लेंस है ना? टैक्स लॉ अपडेट्स समझने में घंटों लगा देते हो? लीगल लेंस टैक्स एडिशन सब्सक्रिप्शन लो, सबसे आसान और जबरदस्त तरीका अपडेटेड रहने का। हर महीने नए टैक्स केस लॉ अपडेट्स सीधे आपकी स्क्रीन पर। मुश्किल भाषा को कहो बाय बाय। हम कठिन शब्दों को आसान भाषा में समझाते हैं। इंटरेक्टिव चार्ट्स, विजुअल्स और वीडियो एक्सप्लेनर्स के साथ सब कुछ बिल्कुल क्लियर। रियल लाइफ केस स्टडीज से सीखो और टैक्स एक्सपर्ट्स से प्रैक्टिकल गाइडेंस पाओ। चाहे आप सीए हो, सीएस हो, वकील हो या टैक्स कंसल्टेंट, बस एक क्लिक में अपना काम आसान करो। लीगल लेंस टैक्स एडिशन सब्सक्रिप्शन आज ही लो और हर अपडेट से आगे रहो। लिंक डिस्क्रिप्शन में है। स्पेशल लॉन्च ऑन फॉर लिमिटेड टाइम के लिए। अभी एनरोल करो। स्मार्ट टैक्स अपडेट्स और आप भी स्मार्ट।
दोस्तों नमस्कार, मैं हूं सीए मनोज लांबा। आज से हम एक नई सीरीज की शुरुआत करने जा रहे हैं जिसमें हम कोशिश करेंगे कि हर रोज शाम 7 बजे हम एक इनकम टैक्स की जजमेंट को आपसे डिस्कस करें, ताकि हम कानून की इंटरप्रिटेशंस को ठीक से समझ पाएं, अपना ज्ञान वर्धन कर सकें और इन जजमेंट्स को किस तरह हम अपनी लीगल प्रैक्टिस में अडॉप्ट कर सकते हैं, इंप्लीमेंट कर सकते हैं, इस बात पर चर्चा कर सकें। तो दोस्तों, आज 20 फरवरी 2025 के दिन से हम शुरुआत कर रहे हैं हर रोज एक नई जजमेंट की डिस्कशन। आप बने रहिए, मैं अपनी स्क्रीन आपके साथ शेयर करने वाला हूं। दोस्तों, आज जो हम आपसे जजमेंट डिस्कस करने जा रहे हैं, ये जजमेंट 13 फरवरी 2025 को, वेरी रिसेंटली 13 फरवरी 2025 को चंडीगढ़ ITAT ने दी है। ये जजमेंट सेक्शन 271 सबसेक्शन 1 हब क्लोज सी से रिलेटेड है, जो कभी कंसीलमेंट ऑफ इनकम और फर्निशिंग ऑफ इनएक्यूरेट पर्टिकुलर ऑफ इनकम की पेनल्टी की बात करती थी 2017 तक। आपको मालूम है कि सेक्शन 271 अब इनकम टैक्स के धरातल पर नहीं है, उसे 270A चेंज कर चुका है, जो अब कंसीलमेंट और इनकरेक्ट पर्टिकुलर्स की जगह अंडर रिपोर्टिंग और मिस रिपोर्टिंग की बात करता है। लेकिन ये एक ऐसा निर्णय है अपने आप में जो सेक्शन 271(1)(c) पे आया है, लेकिन आज 270A में भी इंटैक्ट रहेगा, क्योंकि इस तरह की पेनल्टियां भी आने वाले समय में देंगे। तो दोस्तों, आज हम आपके साथ डिस्कस करने वाले हैं एक बहुत ही इंपॉर्टेंट जजमेंट, जो जजमेंट है सेक्शन 271(1)(c) पर। 271(1)(c) बात करता है फर्निशिंग ऑफ इनएक्यूरेट पर्टिकुलर्स ऑफ इनकम और कंसीलमेंट ऑफ इनकम। चंडीगढ़ ITAT ने एकम रिजोर्ट जीरकपुर वर्सेस ACIT सर्कल 5 सब सर्कल 1 चंडीगढ़ के केस में एक महत्वपूर्ण निर्णय दिया। ITAT ने ये निर्णय दिया कि सेक्शन 271(1)(c) की पेनल्टी एस्टिमेटेड बेसिस पर असेस्ड इनकम पर नहीं लगाई जा सकती। मैं एक बार फिर अपने शब्द दोहरा रहा हूं। ऑनरेबल ITAT चंडीगढ़ ने इस हिस्टोरिकल निर्णय में कहा कि सेक्शन 271(1)(c) की पेनल्टी एस्टिमेटेड असेस्ड इनकम पर नहीं लगाई जा सकती। क्या था ये केस, क्या हुआ आर्ग्यू, हर चीज आज हम डिटेल में डिस्कस करने वाले हैं। पहले मैं केस की साइटेशंस बता देता हूं। यह निर्णय दिया गया ITAT चंडीगढ़ द्वारा एकम रिजोर्ट के केस में। एकम रिजोर्ट के केस में एकम रिजोर्ट वर्सेस AIT सर्कल 51 चंडीगढ़। The decision is pronounced by Income Tax Appellate Tribunal Chandigarh Bench A. The quorum of member is Shri Vikram Singh Yadav, accountant member, and Shri Paresh M. Joshi, judicial member. This judgment was pronounced on 13th February 2025 against the case number IT Income Tax Appeal number 42/Chandigarh/2024 in respect of assessment year 16-17, which was the last year for this section 271(c). What was the summary of the judgment? The core question involved in this judgment is, can an income tax penalty under section 271 subsection 1 clause C, can an income tax penalty under section 271(a)(c) be imposed when the underlying income addition is based on an estimated net profit? So friends, the tribunal decision on this issue is, the tribunal held that the penalty was unsustainable in law, preliminarily because the addition was not derived from direct evidence of concealment but based on the estimated assessment. But the tribunal has decided, the tribunal tries to give the message, the penalty for concealment or as on the date of in respect of underreporting or misreporting of income can be levied only when there is concealment, or now at present time whether it is underreporting or misreporting. And on the basis of that verdict, on the basis of that decision, the penalty order was set aside, bringing satisfactory relief to the assessee. Now, what are the issues framed? What are the issues framed in this judgment? What are the issues framed? Issue number 1. Whether a penalty under section 271, subsection 1(c) is justifiable when the income addition is based on estimated net profit. The second issue, whether the penalty notice suffered from legal infirmity due to its failure to explicitly delineate the nature of penalty. Number 3 issue, whether the imposition of penalty is sustainable given that similar penalty for previous assessment year was dropped on identical grounds. What are the arguments presented by the both parties? First, we will discuss on the arguments presented by the appellant. In this case, appellant was the Ekam Resort, but the council of Ekam Resort discusses in this judgment. The arguments presented by the appellant is, the addition of rupees 5,25,346 was made on estimated net profit of 24.50, while the assessee originally declared a profit rate of 22.72%. First reason, this first contention of the appellant is, the addition is made on estimated basis. Second, since the books of account were rejected and the income was assessed on the basis of estimation, no deliberate concealment or misrepresentation. Please note this word. In this case, even the books of accounts were rejected by the AO. there is no deliberate intention to evade the income on the part of assessee, or there is no misrepresentation by the assessee. This is argued by the counsel of the appellant. Third, very clear. The AO or the counsel of the appellant also argued that the show cause notice under section 274 for asking why the penalty should not be levied for knowing any reasonable cause for that is itself defective. Is itself defective because as it is failed to specify, whether each penalty was imposed for concealment of income or furnishing inaccurate particulars of income. Though in show cause notice, it is very necessary that whenever a show cause notice comes to you, all the counsel are requested what specific charge has been framed against you. In this case, the AO failed to made the specific charge. The notice under section 274 has note where mentioned that whether the penalty they want to levy is in respect of concealment of income or furnishing of inaccurate particulars of income. For this, the counsel of the AO, counsel of the appellant has put reliance on certain judicial pronouncement, which I am discussing with you. That is Anil Abubhai Odera versus ITO of ITAT Rajkot, CIT versus Sahu Construction Private Limited, Allahabad High Court, CIT versus Aero Trader Private Limited, Delhi High Court. And what was the respondent consideration? What was the department consideration? I will also discuss. The department in this objection has said, the department counsel in this objection has said penalty was justified. The department DR district attorney or revenue authority has had that the penalty was justified because insufficient documentary evidence was provided by the SSC. Second, non-cooperation during the proceeding suggesting tax evasion. Third, the basic ground the counsel of the department has given, rejection of books under section 145 of section 3 indicates unreliable record. Three contention has been taken by the department. And now, what the decision and judicial pronouncement given by the court? The court has said that, that penalty under section 271 subsection 1 clause C is not sustainable when the income is assessed on estimation after rejecting the books of account. If the penalty under section 271C has been initiated after rejecting the value, even then it is not sustainable until it has been established that there is a concealment of income or inaccurate particulars. The addition was not due to, please note the wording of the court, the addition was not due to misrepresentation or concealment, but rather than it is because of assessment on estimated basis. And estimation by the AO didn't mean that the SSC has deliberately not disclosed the fact of their income or misrepresented their income. This is very, very important fact, my dear friend. The third very thing, the penalty notice under section 274 issued by the department, the show cause penalty notice issued by the department has itself defective because it fails to point out whether it is in respect of charge of concealment of income or furnishing of inaccurate particulars of income. The third, on the basis of these two very important things, the penalty order was quashed and the appeal was allowed. The appeal was allowed in the favor of the SSC. And what are the legal issues settled by this judgment? The first issue settled by this judgment, penalty is unsustainable when income addition is based on estimation. Second, Section 275 show cause notices in respect of penalty must clearly specify the charge or default, whether it is in respect of underreporting or misreporting or concealment or misrepresentation. Judicial consistency. Consistency must be maintained across assessment year in penalty proceedings. Then what are the key takeaways from this judgment? First takeaway is no penalty can be levied on the basis of estimated assessment of income on estimated basis until misrepresentation or concealment has been proved. Notice must specify specific charge. And third very important thing, now tax professional can argue that if there is a case where the penalty under section 270A has been initiated now because the section is underreporting or misreporting of income, is sustainable only when there is a specific charge either of underreporting of income or misreporting of income. Second very important thing, my dear friend, which you have to point out, जो आपने ध्यान रखनी है, अगर एस्टिमेटेड बेसिस पर एडिशन हुई है तो इसे कंसीलमेंट या मिसरिप्रेजेंटेशन नहीं किया जा सकता. इसके अकॉर्डिंगली हमें लिटिगेशन स्ट्रेटजी बनानी पड़ेगी. व्हाट आर द नोटेबल जुडिशियल ऑब्जर्वेशंस फ्रॉम दिस जजमेंट? Penalty proceeding cannot be sustained when addition are based purely on estimation methodology. The second very important thing, the absence of speciality in the penalty notices violate their enforceability. Two very important things the court has said. First, I am reading with you. Estimation of profit based on higher rate without proving willful concealment cannot attract a penalty. Second very important thing, the penalty notice must clearly specify the charge, whether it is in respect of misrepresentation or concealment. Ambiguity in show cause notice issued by the AO renders the entire penalty proceeding ineffective. What are the cases referred? I have already discussed. And what was the effect of this judgment? This is a very, very welcome and good judgment given by our jurisdictional ITAT Chandigarh, which we can use in our day-to-day practice. I hope, my dear friend, you will really like this presentation and discussion on the judgment. So I hope you really like it. If you like it, please tell me in the chat box how was the discussion and what further topic you want to cover. Every day we will discussing a new judgment. Tomorrow we will come again and discuss a very important judgment given by the ITAT Nagpur on the issue of section 263(1) revision, whether revision can be done if the assessment has already been done under section 143 subsection 3. If scrutiny assessment is already there, whether this assessment can be done or not. Please, all the viewers who are listening me, who are viewing me, who are learning from me, tell me in the chat box how was the discussion, what further things we can include in that. Otherwise, we will meet tomorrow at same time to discuss the issue and very important judgment of ITAT Nagpur on section 263 issue. Please join tomorrow at 7 a.m. also. All the participants of today discuss. Be with us, grow with us, and enlarge your knowledge to increase your practice of pan-India basis. It is the vision and vision of CA Manoj Lamba. Thank you so much. Any question on today's discussion is most welcome. You can ask me any question with regard to this judgment. I am here to reply the same. I'm waiting for your questions. Otherwise, we are winding up the session. Anyone want to ask any question? Please write in the chat box.
क्या आप भी कानूनी जजमेंट्स को समझने में घंटों लगाते हैं? ये काम अब आसान हो सकता है. पेश है लेक्स जीपीटी, एक ऐसा एआई टूल जो आपको किसी भी कानूनी जजमेंट को सेकंड्स में डिकोड करके समझने में मदद करेगा। चाहे कोई भी कानून हो, कोई भी जजमेंट हो, लेक्स जीपीटी आपको देगा सटीक और तेज विश्लेषण। और खास बात, आपको मिलेगा फ्री स्टैंडर्डाइज्ड प्रॉम्प्ट जो आपके एनालिसिस को और भी बेहतर बनाएगा। अब समय बचाइए, काम कीजिए स्मार्ट और बढ़ाइए अपनी सफलता की संभावना। लेक्स जीपीटी किसी भी कानूनी जजमेंट को समझें तुरंत और आसानी से। अभी खरीदें और आजमाइए।
धन्यवाद मेरे को ज्वाइन करने के लिए। धन्यवाद।